Good afternoon, everyone. Welcome to the latest Housing Snapshot webinar. I'm just going to wait for a few more people to join before we kick off today. I'll just give it another 30 seconds for people to join in the webinar. Okay, right, lots of people here now, so I shall start off. We've got a slightly different format for today's Housing Snapshot webinar. No slides. You've just got me, Simon Murphy and Jonathan Parker, JP, and we'll be going through some of the latest news in the social housing sector. Now, there seems to have been so much going on in the sector lately. Just in the past few days, we've had the government dropping its policy to abolish leasehold tenure, and that's been quickly followed by the publication of the Renters Reform Bill, and Simon's going to be talking to us about that in a little while. We're also going to be talking today about some of the themes that came out of the excellent CIH Brighton Housing Conference earlier this month. So as I said, Simon's going to talk about the Renters Reform Bill. JP is going to give us an update on the Social Housing Regulation Bill and talk a bit about the Decent Homes Standard. And if there's time, I'm going to wrap up with an update on the Building Safety Act and shared ownership. Please put any questions in the Q&A function and we'll pick those up as we go along and ask us any questions about what we're talking about today, or throw us some curveballs and JP will answer those. If you've got any technical difficulties at any stage during the webinar, please let us know during the chat function and we will try and help. So to kick things off today, I wanted to talk a bit about the themes coming out of Brighton and about a couple of the speakers who I found particularly interesting. Now, the first one was Toby Lloyd. Now, he's a housing policy expert and a former advisor to Theresa May. And he spoke at the first session at Brighton in a session called The Big Picture, Politics and Policy. He gave us some sort of really interesting insights into where housing sits in the political landscape. And apparently it's never top of the agenda, but somewhere in the top 5 or top 10 issues of the day. One point he made is that the term affordable housing has become a toxic phrase in political circles. The perception that affordable housing is often not actually affordable. And as I've thought for a while, it kind of implies that all other housing is unaffordable. So he was saying it's better now just to talk about social housing and to talk about home ownership. He also said something about the government wanting house builders to be more like registered providers and not actually the other way around. He said that the government does acknowledge and appreciate the focus that registered providers have on providing quality housing and taking a more long-term view of housing. A couple of the other standout speakers for me, and actually the most powerful session I found at the whole conference, so that was Peter Apps, the Inside Housing journalist, and Jill Kernick, who is a former Grenfell resident and an author. And they were speaking about Grenfell and whether 6 years later the lessons have been learned. I followed Peter's articles in Inside Housing, as I'm sure many of you have, but hearing him and Jill speak so passionately about the circumstances that led to Grenfell kind of really brought it into sharp focus. And for me, the sort of takeaways were how policies and politics drove deregulation, and also this sort of theme about the tension between profit and people, and how so many of the companies involved in the refurbishment of Grenfell were willing to put profit above safety. I think that kind of tension between profit and people is something that the sector is going to have to grapple with a lot more going forwards. The indications seem to be, and this was reflected in some of the talks at the seminar, at the conference, that there is going to be a lot more private finance coming into social housing. The future is private funding models and partnerships between housing associations and for-profit. So you're going to have to deal with that kind of tension, as I say, between profit and people. I bought Peter's book, Show Me the Bodies, How We Let Grenfell Happen, as soon as I came back from Brighton. And JP's reading that at the moment. How's it going, JP?
It's going as far as it's sat on my to read shelf still. But obviously, Estelle, you've read it front to back. So what did you make of it? I mean, I gather it's quite a powerful read.
Yeah, it's pretty tough going. I was quite miserable when I finished it. But I think it is an important book for everyone to read if you haven't already, because I think anyone involved in housing and development kind of needs to understand the circumstances that led to the Grenfell tragedy. Yeah, I'm going to pass over to Simon now, who's hopefully going to lighten the mood a bit, talking about the Renters Reform Bill.
Thanks, Estelle. I'm not sure this is too much of a jolly topic either, but I'll try and be as jolly as I can. So I just wanted to talk about the headlines of the bill, and possibly the kind of biggest takeaway is that the Renters Reform Bill proposes to end assured short-hold tenancies. So all previously assured short-hold tenancies will now be periodic tenancies. And as the short-hold is to be abolished, Section 21 is also to be abolished too. Many of my non-RP landlord clients use Section 21 to terminate ASTs where there are rent arrears or ASB is occurring. At the moment, it's quicker and cheaper to terminate a tenancy using Section 21 than by serving a Ground 8 notice. Some courts have 6 to 8 months or longer delays for a first hearing. So if you want to turf out a nuisance or non-paying tenant, when the bill comes into law, landlords may be stuck with these tenants for a much longer time. The bill promises something very woolly about speeding up the court process, but no more money has been offered. So I'm afraid I'm very sceptical that after 13 years of austerity and cuts, that anything will get better with the court system. And I'm not sure that the proposals will do much to prevent homelessness. The grounds for possession are being changed so that landlords can recover the property in circumstances where they wish to sell or move in close family members. And that includes siblings, children, grandparents and grandchildren. And from my personal perspective, nearly all of the no-fault Section 21 notices that I've dealt with are in circumstances where landlords wish to sell or move their children in. So I'm not sure that this will have the big impact on homelessness that the government is expecting. The grounds relating to rent arrears and ASB are being beefed up. So in theory, it will be easier to evict tenants causing ASB or tenants that have significant or persistent rent arrears. But again, this is subject to delays in the court system. If the government brings in the act and does not sort out the court system, I wonder whether it may deter some investors from purchasing a buy-to-let house, as they'll need to factor in not getting rent and not getting possession for many months and months. And this could mean that they can't afford to take the risk with a buy-to-let. Perhaps that might be a good thing, though, as it could stop investors heating up the housing market. On rent increases, the bill provides that a landlord can increase the rent, but only to market rent. It can't go above. If a landlord proposes a rent that is above market rent, or the current mechanism provides that, say, it has a kind of index link provision that takes it above market rent, tenants will be able to apply to the first tier tribunal to assess whether or not the proposal is above market rent or not. The bill proposes a new private sector ombudsman will be created. Private landlords must join this. It's proposed that the ombudsman will deal with issues like failure to repair within a reasonable time, failure to decorate, etc., and be quicker, cheaper and less adversarial than the court process, which does sound good. The Act will create a private rented property portal to help landlords understand their legal obligations and to demonstrate compliance. And it will also give better information to tenants so that they can make informed decisions when entering into a tenancy agreement. The portal will be compulsory for landlords to join. It will allow local authorities to target enforcement activity where it's most needed, and the fines are going to be much larger. I'm hopeful that it may encourage local authorities to actually enforce them. Maybe local authorities will actually employ tenancy relations officers like they used to. There'll also be a compulsory redress scheme, which landlords have to sign up to. And if landlords don't, that will result in fines of up to £5,000 or £30,000 for a repeated breach. Possibly one of the most touted areas of the bill is about pets. Tenants are going to be allowed to request a pet to join them in the property. The definition of pets is kind of creating interest. Pets are defined as an animal kept by a person mainly for personal interest, companionship, ornamental purposes, or any of the above. I've no idea what personal interest extends to, and suspect that there might be lots of arguments over ornamental purposes. Despite the hype, I don't think that the Act takes the pet issue much further. It simply adds an implied term that a tenant has a right to request to keep a pet and that a landlord cannot unreasonably refuse such a request. But where the landlord's own lease forbids pets or requests the superior landlord's consent, the landlord is to request this, and it's not going to be unreasonable for a landlord to refuse permission for a pet if their superior landlord has refused consent or if the landlord's own lease forbids pets. If a pet is allowed, it will be reasonable for a landlord to request the tenant to take out insurance for damage by the pet. The bill proposes a tweak to tenants' notice to quit. Under the bill, a tenant's notice to quit has to be for a period of 2 months and can be given at any time, even in the first 2 months of a tenancy. Unlike the usual common law provision, the tenant's notice to quit may be withdrawn if the landlord and tenant agree in writing to the withdrawal. Obviously, at common law, you can't withdraw a notice to quit. Tenancy deposits. That's changing too. So the sanction of not being able to serve a Section 21 notice if the landlord has complied with the tenancy, hasn't complied with the tenancy deposit requirements will be no more. However, unless there is ASB, no possession order will be granted unless the deposit has been held within an authorised scheme. The bill beefs up the provisions on unlawful eviction. So civil penalties are introduced on top of the underused prosecution from eviction, and there is a maximum civil penalty of £30,000. A real positive is that the bill proposes that the decent home standard should be applied to the private rental sector. It will also be unlawful for landlords and agents to have blanket bans on renting to tenants in receipt of benefits or with children, to aim to ensure that no family is unjustly discriminated against when looking for a place to live. But the bill is light on detail on how this would be enforced. Okay, so that's all I wanted to talk about on renter reform, but I wanted to finish with some more comments from Brighton. As someone who trained as a housing management solicitor in the 1990s with Oxford City Council, where these issues were really prevalent, it was depressing to learn that still only 2% of social housing tenancies are furnished. Furniture poverty obviously severely affects people who are fleeing their home as a result of domestic violence, or people who are rehoused after being homeless. It would be good if RPs could consider granting more furnished tenancies to accommodate these two groups of people in particular, but also people leaving the care system. As an aside, The Renters Reform Bill proposes a ban on ASTs, but homelessness legislation provides that previously homeless people should be given a 2-year starter AST. So there's a need for more joined up thinking here. The other thing that's not new, but again, CIH raised it in Brighton, was the connection between ASB and rent arrears and domestic abuse. So CIH recommended sympathetic policies where RPs worked hard to understand, was there a domestic abuse reason for the rent arrears or the ASB? Okay, I'll get off my soapbox. That's the end of my slot for today. I'll hand you over now to JP, who's going to talk about the Social Housing Regulation Bill.
Thanks, Simon. So the Social Housing Regulation Bill, obviously the key is in the name, that is very specific to social housing. I think just looking slightly back at some of the things that Simon was picking up there on the Renters Reform Bill, that's a bill that very much sort of flips between private sector specific points and social housing sector. So the PETS provisions, for example, I think, well, I haven't read it recently, but I think the PETS provisions, for example, mainly apply to the private rental sector. I'm hoping if I'm wrong, Simon will interject, but basis of silence, I think I'm right. So turning to my part then, obviously it's a brilliant couple of days at Brighton. From a legal standing, one bill for me quite rightly dominated much of the discussion, namely the Social Housing Regulation Bill. Before I consider some of the specifics that came out of Brighton, I will just give the briefest of summaries about what the bill is, just in case anyone attending today is particularly new to the sector or would simply welcome a refresher. So the government is looking to reform the social housing regulation via the Social Housing Regulation Bill. They have directed the regulator of social housing to review the consumer standards that all RPs must adhere to. The bill is in the final stages of consideration, and it is expected to receive royal assent this summer. I dare say we will be covering the bill in a standalone Snapshot webinar later on in the year, so do keep an eye out for that. As it stands, the bill currently includes the following. Firstly, the introduction of AWAB's law, which will mandate landlords to address reported health hazards within specific timeframes. The Housing Ombudsman will gain new powers, including the ability to publish a complaint handling code. The regulator will receive stronger enforcement authority, allowing them to impose unlimited fines and to conduct inspections. And there will be a requirement for all social housing managers to have a housing management qualification regulated by Ofqual, which will be an equivalent to a level 4 or 5 certificate or diploma in housing, or a foundation degree from the CIH itself. I mean, that very point alone has caused some concerns for RPs, particularly regarding the time and cost implications of having to fund and allow time for their managers to undertake these qualifications. So looking at Brighton specifically, the key speaker for me on this topic was Fiona McGregor, the Chief Executive of the Regulator of Social Housing. Fiona focused on the regulator's policy paper titled Reshaping Consumer Regulation, Our Implementation Plan. And this is the RSH's steps that it will implement to bring into effect the legislation within the Social Housing Regulation Bill. The regulator is intending to consult on new consumer standards this summer, provided the bill receives royal assent. The consumer standards will ensure that landlords listen to their tenants, communicate effectively, have good quality information about the condition of their housing stock, and provide responsive and accessible landlord services. They will also be issuing a code of practice on consumer issues. Fiona made it clear that this will be prescriptive, but that the regulator does not want to specifically tell landlords how to meet the standards and instead allow them to adopt their own approach. And upon hearing that, there was definitely a sense of murmurings from the audience who, presumably considering the pressures that are already being put on RPs, were perhaps hoping for greater direction from the regulator. From my end, I can see that, or I think that a balance is needed to be achieved between too much being dictated by the regulator and too little. Take the legal world, for example. For much of my practicing career, we've had the SRA Code of Practice. That was until 2019. That code was accompanied by a list of indicative behaviours. And as a lawyer, if you adopt those indicative behaviours, you were not likely to fall foul of the code. So maybe something similar would be welcomed by RPs. Then again, the SRA removed those indicative behaviours in favour of a more straightforward mandatory provision. So it's obviously a very difficult balancing act to help understand and implement codes of practice. Fiona and the regulator's message throughout the whole presentation was, as it has been for some time, that RPs need to prepare now. Or frankly, if you're only just starting to prepare now, it's probably a little bit too late, but nonetheless. And to prepare now means to prepare to be able to ensure that you'll be able to demonstrate to the regulator that you are meeting the necessary standards. This prompted a question from one of the audience members, and obviously I paraphrase, but it was along the lines of, will the regulator be the new Ofsted? As we're all aware, being associated with Ofsted right now is certainly less than ideal. And actually, when I was preparing my notes for today's webinar, I did come across a government press release from last June, which focused on the regulator's forthcoming stronger powers to issue unlimited fines, enter into properties on 48 hours notice, and make emergency repairs. And the title of that press release was Ofsted-style inspections and unlimited fines for failing social landlords. Quite unsurprisingly, Fiona was keen to distance the regulator from being tagged as a new Ofsted, and she focused on the duty of care that the regulator has towards RPs. She stated that they will be taking a balanced and proportionate approach and will not be the punitive regulator that some perhaps fear. That being said, notices and judgments will continue to be published, but they will be written in a balanced manner, and it will not be the case of naming and shaming. A second question came in regarding whether there'd be any opportunities for RPs to rebut any judgments issued by the regulator. And actually, there was some resistance from Fiona regarding this. It seems that the regulator's position is that if an RP believes evidence is or has not been looked at, then it must alert the regulator very quickly indeed, because otherwise the regulator will not be getting involved in extended debates about a published score. But to soften the tone slightly, she did state that there would be an ongoing exercise by the regulator keeping its overall approach under review, and will continue to discuss and engage with RPs about changing the direction of that approach if necessary. So that mostly covers the social housing regulation bill. There was also talk about the decent home standard. I heard from both Baroness Scott and Fiona McGregor about this. And the review that has been revised recently obviously has been further accelerated by the tragedy of AY Bisac. So just taking a step back slightly, just to cover what the decent home standard is again, just in case anyone needs a quick refresher. It currently only applies to the social rented sector. Its aim when established in 2000 was to provide higher standards for tenants to ensure they all live in a, quote, decent home, close quote. The standard requires properties to meet certain criteria, such as having a safe and reliable heating system, adequate insulation, functioning windows and doors, and a reasonable state of repair. But the issue really is that what the standards consider to be a decent home has not been updated since 2006. And frankly, it was considered to be long overdue. So as part of the review and the preparations for implementing the new consumer regulation, Fiona was keen in particular to stress that the regulator will be continually involved throughout this process. We should note, for instance, that they are kicking off the second wave of consumer inspection pilots. And of course, inspections will be very much at the heart of ensuring and monitoring compliance with the updated decent home standard. Now, interestingly, one bill that didn't feature in any of the sessions that I attended, certainly, was the Levelling Up and Regeneration Bill. But Estelle, and I'll be looking to you on this one. We had quite a few breakout sessions, of course, in between sessions. And I recall that you spoke to a few delegates about this particular bill. Were there any points that you could take away from these discussions at all?
Yeah, we were having a chat with quite a few people involved in planning, and there is understandably a lot of concern about the Levelling Up Bill and the new infrastructure levy that's being proposed, and concerns that how that is going to secure an equivalent amount of social housing as the Section 106 system does at the moment. But perhaps most interestingly, people who are more on the policy side of things were expressing some concerns that actually the Levelling Up Bill might not now go ahead because we might run out of parliamentary time to go through it properly. So kind of watch this space, I think, on the Levelling Up Bill. Thank you, Simon and JP, for your bits there. I was going to close by talking a bit about the Building Safety Act, but we're running a bit short of time. So what I will do instead is my colleague Katie has done an article on that. So we'll get that published with that update about the Building Safety Act and shared ownership. But quickly on shared ownership and the Renters Reform Bill, one important part of that bill is just slipped in at the end that leases over 7 years are not going to be capable of being assured tenancies. So that takes shared ownership away from being assured tenancy and very quickly and perhaps quite cleverly addresses one of the major criticisms of shared ownership. I'll go into more detail about that on another webinar, I think. Just to be clear, that's not kind of law yet. That will come into play as and when the Renters Reform Bill becomes law. So before we close, just have a look, yeah, Q&A.
Looks at Q&A, sorry, yeah, absolutely. We have got sort of one question, and it's relating to procurement. And the question is, do we see that professional procurement has increased in the sector in recent years, or is it seen as a compliance and finance function across the sector? For me, it's a slightly difficult one to answer, but from what I can, obviously what I recall, particularly from the schedule of the conference, was there was a specific section, wasn't there, dedicated to procurement. So obviously the CIH conference focuses on the key parts for the industry and wants to talk about the key parts. I didn't attend that particular webinar seminar, so I'm afraid I can't comment on the actual content, but the mere fact it appeared on as a headline feature must show that it's very much at the forefront of the sector.
Yeah, I think
good procurement. That's
a really good point. I mean, I didn't go to that session either, but I mean, procurement did come under, it was put under the spotlight after Grenfell. Peter's book goes into quite a bit of detail about the procurement process and some of the flaws in that on Grenfell. And yeah, I think it can only be a good thing that the sector is looking into procurement and hopefully learning from some of the lessons of what went wrong at Grenfell. If there are any questions, put them in for us quickly because we've only got a couple of minutes left. Before we close, I did want to do a quick plug for a couple of upcoming events we've got. Firstly, there's the Housing Learning and Improvement Network, Housing LIN's webinar tomorrow about shared ownership for an ageing population. That's got Lord Best on it and some other important people who are going to be speaking about shared ownership and the challenges of housing for older people. And I'm going to be on that webinar with Saffron Housing, who are going to be talking about their new extra care scheme in Norfolk. Also, if you are Cambridge way, House Percival is hosting a breakfast development seminar on the 13th of June. Myself and Simon are going to be speaking at that, and I think we'll be putting links to sign up for that in the feedback form at the end of this webinar. As ever, please, if you get the feedback form, do fill that in. It's really helpful for us and helps us to work out what topics we're going to speak about next and cover in future webinars. So that's our time up for today. Thank you very much for joining us. If you've got any queries or want to discuss anything that we've talked about, please do contact myself, Simon, or JP. Thank you. Bye-bye.
Thank you. Bye.
Bye.